Let's hear the suspended CJ briefly. Yesterday, she gave a press conference, 47 minutes. I'm bringing you some highlights of her speech that she addressed. You know, you can say she addressed the media, but actually she addressed the nation. She addressed the nation through the media. That's more accurate. So let's hear some of the highlights.
The public officials who have been summoned, supposedly on subpoenas, without the issue of subpoenas, just come and swear oaths and present documents to the committee as exhibits. The witnesses themselves do not have the petition. They do not know the allegations in the petition, and so they cannot answer questions on the petition. And when they finish submitting their documents, my lawyers are called on to cross-examine them. Since 23rd May 2025, this strange process has been followed up, and witness after witness has been called, like Nebuchadnezzar's situation, in which he demanded that the magicians in his court should tell him his dream and also interpret it. My lawyers are left to guess which allegations in the petitions that I received on 27th March are supposed to be the subject matter of the testimonies that the witnesses have referred to. Anyone who has been to the Circuit Court or the High Court and made subject to the rules CI 47 will know that those rules never conceived that a hearing can be conducted without the claims, the defenses, and the issues being carefully laid out before the parties and accepted by all of them before a hearing starts. Ladies and gentlemen, it is this total absence of compliance with all known rules of fair hearing that has caused my lawyers to file applications for judicial review in the High Court to declare all the proceedings void. Because the clear danger is that through this flagrant violation of CI 47 and the darkness of the current proceedings being held in camera behind the walls of a Edu Lodge, my lawyers and I can come to the end of the proceedings. The evidence will show that every one of those allegations in the petitions that were given to me on 27th March is unfounded and untrue. And yet, the committee can dig up some allegation from whatever documents they claim to be having from the president, which they have not shown to me, and purport to enter a recommendation for my removal on that basis. Allow me to say that this is totally unknown in the rule of law in this country. If it was lawful, I would have no reason to alert the nation of the dangers they represent. It is the violations of law that have forced me to bring these matters out in the light of day. The final and fourth reason for this statement is that I have heard on several occasions from loved ones, persons who care, persons who may not know me beyond my public duties, and many who think that since these proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long before it started. I thank everyone who has engaged in this conversation out of concern for my safety and well-being. Let me assure everybody that I am not seeking to cling to a title or a position. However, as a lawyer of 38 years standing, a judge of 21 years standing, and Chief Justice who has served the rule of law all my working life, in fact since I was 25, it is my onerous duty and obligation to speak up concerning anything that is extremely wrong with the administration of justice in this country. This is what I do every day. The situation I have been confronted with has shown me a model of injustice that I would never have thought possible if I had not been exposed to it. This is why, despite great personal discomfort, I have decided to marshal every effort in law and leadership to answer to this situation. Again, resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you failed to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on. Therefore, if false claims are made against a judge or commissioner or other public office holder subject to Article 146 proceedings just to achieve a political agenda, the solution cannot be to resign or voluntarily retire out of frustration, pressure, or fear. You would only subject yourself to two cruelties: a judgment based on false claims and loss of everything you have worked for. It may well be that the efforts being made are intended to frustrate me so that I resign, so that the architects of the scheme can go back into the media and say that the wild and unfounded allegations were not defended because they were true and I had no defense to them. As Chief Justice of the nation, who has been given the privilege and obligation to lead administration of justice, I should not turn tail and run when I know the implications of not defending false and unwarranted charges. If I resign under these circumstances, I will be saying that this flawed, unknown, and opaque process is acceptable.
The government denied that it was a political witch hunt and that the processes have been outlined in the article, is it 146, which have to be... so I think the argument revolves around 146 because one of the main things he raises has to do with the opacity of the process and the unfairness thereof. The government is strenuously pointing out that 146 is very clear that it has to be in camera. And I think some people have said that maybe this particular situation should let us have a rethink of that whole 146. Mm-hmm. Because I think it's the first time we are seeing it manifest in such a way. Even though you've said that in the past, some CJ has been removed.
And some other judges.
Yes, I think the process has been brought to the fore very strongly now. So whatever happens with this particular case, I think it requires a second look, do you not think? The way, for example, the whole prima facie case, whether there's a basis for it, who determines that, and then the hearing, is it better to do it in camera? Because some people also say that if you do it in public, you are also possibly painting the person black before it's I don't know. You know, when it comes to constitutions and the way they are written, I don't know how we go into the mind of the drafters and why they they make the provisions they make, and whether we who are living it out have the discretion to change it. I'm not even sure where to go with that.
Well, the fact is, the current system has serious weaknesses, and I have argued that it calls for a complete review and overhaul of that entire provision, because in my view, it undermines judicial independence in many ways, because already the president is clothed with too much power when it comes to appointing people to serve in the judiciary. I take the view that we should have an independent commission or institution within the judiciary that would do its own vetting, determine who is qualified, who is not qualified to become a justice of the Supreme Court or justices of the superior courts, and they get elevated as such. If there should be any role whatsoever to the president at all, it will be only after an appointment is made, and then he symbolically would hand them the scroll of office without actually having any intimate role to play in the process. Of course, parliamentary involvement may be necessary if we think that it helps. But I think the more fundamental question is whether it is in the public interest to hold a critical, what do you call it?
Hearing
like this away from the public
camera or
Exactly. The framers of the Constitution, if you read the various discussions that went into the decision to create the regime the way it is, wanted to avoid a situation where what is happening during the process impacts the image of the judiciary, as to say, take away from, the credibility of the judiciary. Because if that institution is bastardized merely because of a conduct or misconduct on the part of a judge, then people might lose faith in the judiciary, and then they will say, okay, we don't believe in this and that. Imagine if it turns out that judges went for cows or maybe dogs and decided to throw cases away, as has happened during the Anas investigations and all of that. So the framers carefully tried to isolate the process.
So in the Anas case, the judges were tried in camera.
Yes, they were.
It was not in public.
Yeah, but you see, the problem at that time was that Anas had released videos of the collections.
What they were doing.
Aha.
But the process of the hearing was in camera.
Exactly.
Okay.
You understand? So then, that people then began to say, so judges were collecting goats and they were throwing cases away. Mm-hmm. That weakens public confidence in the judiciary. And if you read the memos and all the things that the framers of the Constitution said, they wanted to avoid situations like that. So yes, we will hear the justice in camera, will determine the matter, and the outcome will be communicated to the Ghanaian people with the removal or clearing. But you see, the other side to that is, if there are rights being violated in camera, who do you cry to? The Chief Justice appears to be alleging that her constitutional rights are being violated in camera. She cried to the committee. The committee is not willing to listen. They don't want to do anything about it. She took it to the courts. The courts have washed their hands away like, biblical times. And so she's left now to speak to the conscience of the Ghanaian public, to put her case out there. Because in any case, in her view, the charges against her have been copiously published in the media anyway. Now, the question is, if there are competing requirements of the Constitution, which one should yield to the other?
Do you give more weight?
That is where the problem is. Because 146 says, no, it is closed. Nobody should know about it. It should be confined to the in-camera hearing. But the woman says that, the Chief Justice says that, well, my rights are being violated.
So let me ask you a question. Whatever happens after this case, assuming the Constitutional Review Committee asks for submissions around 146, what would you propose?
Well, so
based on the lessons from all that has happened from Anas to this particular one.
Yeah, so as I've argued elsewhere, I think the process itself should be open. I think it should be open. And discretion left to those presiding over it to determine on case-by-case basis which one should be out of the public view. So, for instance, if the situation is so serious as to impact national security, the national security considerations and public policy considerations should intervene and say, okay, on this particular matter, we are not going to hear it open.
So like the way Parliament does.
Exactly.
When they have a hearing, they can say for some, open for some. So that the committee decides as and when.
Exactly.
You don't lock it into law to say it should be in camera or not.
No, willy-nilly. No, I don't think.
But who
that.
makes the determination? Would this be the Parliament of Ghana or the President or the Council of State? Who should make that determination?
So again, I am saying that we should remove the role of the President in determining who should be on the committee.
Okay. So the committee should already be known by way of...
Yeah. So there should be, in my view, a disciplinary institution within the judiciary itself.
Okay.
Which would have the authority to receive complaints like this.
With known members.
Exactly.
Or the members are based on positions. Or they
Not
can say maybe a
necessarily
couple of high court judges or whatever.
exactly.
But who empanels them?
But my view is that they should be former justices of the Supreme Court.
Former.
Yes.
But who will choose them? Will it be Parliament or the President?
No, so the judiciary within itself should
But what if the person being tried is the CJ? Who will choose the people?
So so if it is this is just like maybe the Attorney General presently. If there is a challenge against the Attorney General for engaging in a conduct, and I'm not saying he's done that, a conduct that is unbecoming of a lawyer, the General Legal Counsel is there to hear that complaint and determine it. It doesn't matter whether he's the Attorney General or not. Some people have some fanciful
The
ideas.
disciplinary committee of the GLC.
Yes. So you see, I want that, in my view, respectful view, that committee set up within the judiciary itself, which is a disciplinary committee that will be responsible for enforcing code of conduct and related matters within the judiciary. And it would apply equally to the Chief Justice, as the case may be.
Well, process continues.
Yeah.
We'll keep
And then
a close
also
eye on
quickly,
it. Yes.
in the case of parliamentary involvement, I take the view that it should not be 5 members sit on the matter, decide one way or the other, give it to the president acts on it. I think if we truly want to guarantee judicial independence, we should move the requirement to a level where you will require 3/4 of all MPs voting that a particular justice of a superior court. So in this case, we are not
So
confining it
whatever
to
the result is, Parliament should get involved.
Yes,
But
Parliament
they
should vote on it. Yes.
And the majority should be very big.
Yes,
Before the wow.
The reason is
So
that
that the legislature can protect the judiciary.
the reason, in my view, is that I think we have set the floor too low. If the Chief Justice goes to have lunch outside somewhere with somebody, should that be a basis for removing the president? I think the bar should be really high. When we see misconduct, we must know it. That the Chief.
But is Parliament not already partisan? So is Parliament the right place to treat this issue?
The reason here is that it forces cooperation. If we all agree, let's assume, for instance, that a justice of a superior court goes to, say, murder somebody, right? The facts prove that he actually did that. In that case, we all, no member of parliament in his right sense will say that, oh, this matter, no, let's go divided on it.
But not every issue is that clear cut. That's the problem.
Yes, that's why I'm saying that even the floor as to what constitutes stated misconduct is too low. That is why I was saying that we needed a CI to clarify what exactly the issues are, because in this case, anything at all appears to go. You understand? A judge sits on a matter, makes a determination, and somebody is not happy and says that, okay, on the basis of that, remove a justice from office. I think that, look, removal from office should be reserved for very, very, very serious offenses against the good people of
because
Ghana.
even Article 127 protects the judge from liability when he's carrying out his mandate, whether judicially or administratively. So you
Exactly.
can't say because you lost the case in court, that's stated misconduct.
Unfortunately, one of the petitions says that a particular decision was made to arrest somebody in the course of judicial duties, and therefore the person should be removed from
But
office.
isn't that why there's a prima facie establishment? Won't that cure or raise the bar?
Unfortunately, as we speak, we don't know what went into a determination as to the presence of a case to answer. You understand? If that document had been submitted to her ladyship, perhaps maybe at least Ghanaians will have a fair idea, okay, what determination was made, why it was made, and all of it. It's a reasoned writing that says that this was the allegation, we looked at A, B, C, D, we tested them, and we came to the conclusion.
But let me ask you another question. Some people feel that she chose the wrong forum, that she should have probably used the Human Rights Court, because she was alleging that her rights were being violated. And as the custodian of the law, who has occupied the position of CJ, the best place for Saka would have been maybe the Human Rights Court.
So I agree to an extent with that view, because I believe that you cannot pick and choose how Article 146 is enforced. But you see, that view also ignores the fact that the woman claims, or I'm not saying the woman, I'm using the Chief Justice claims that the committee has failed to address her concerns. The Supreme Court has failed to intervene. That notwithstanding, she's filed an action at the High Court seeking to protect or vindicate her rights. But you see, the Constitution under Article 21 allows for free speech. That includes speaking in defense of your own rights. So the question is, if Article 21 clashes with 146, the requirement of secrecy, which of them should
so you are saying a lot of this is which one you weigh. Let me read a couple of comments for you before you go. Good morning. There has not been any previous process of impeachment of a certain CJ like we are witnessing. CJ Seyaku Kosa was dismissed from office by President Nkrumah, who had such a power to dismiss the CJ under the 1960 Constitution. There was no impeachment process per se. CJ Lankwe Bannerman was also dismissed by General Champong in the 1970s. This is somebody who has a lot of history to add. You are going to make a quick
but
point.
He's right. This is a historical,
novelty
event that is happening.
Yeah.
Yes, it's also novel. I just wanted to draw Sky's attention in raising Article 21. Granted that this is the Constitution and it has the superiority in terms of supremacy, but the rules of professional conduct also require that we don't take to the public proceedings in the court. So it appears
that's where the issue is.
That she may also be, for want of a better expression, compromising the process she's saying is being meted out to her unfairly. She's also participating in that.
So I asked a question on some other platform that if, let's assume that justice is being investigated for having done one wrong or the other. She goes there every day. They line him up on the table and lash her or him 24 times. Draws the attention of the committee to it. The committee says, well, we are not concerned about, we are investigating you for stated misconduct and blah, blah, blah. Files an action at the Human Rights Court or maybe at the Supreme Court, depending on the circumstances of the case. They say, oh, we don't want to do anything about it. It is a closed matter. Are you saying that merely because the provision says that you should confine the matter to secrecy, he or she should not come out and complain?
I hear your point.
So the point I'm making
depending on how the person feels violated and the context around the issue, you are prepared to accept the recourse to the public.
Exactly. And I cite a specific...
Depending on
the circumstances of the case. Right. Because there's a principle of derogation in law which says that in appropriate cases, what is the general rule can be departed from in protection of some other fundamental rights. So if, for instance, I am being killed behind closed doors because I'm being investigated, I should not submit to the process when I do know that exactly. So in that case, if she feels that she's there, it is for her to justify it. You understand? And then if people are going to sit on it and determine whether there is a breach, they'll have to weigh the two sides before coming to a conclusion.
Well, the law is very complicated. Let's make it simple. But thank you guys for your insights on this.